A joint venture agreement is a crucial document when multiple individuals start a business together, as it clearly defines the rights and obligations of each party and the method of business operation. This agreement helps prevent disputes among partners and establishes a foundation for stable business operations. Let's look at the key points that must be confirmed when drafting a joint venture agreement. First and foremost, the roles and responsibilities of each partner must be clearly defined. It is essential to specifically outline who will be in charge of which tasks and what authority they will possess. Simply stating titles like representative or director is insufficient. The scope of authority in decision-making processes and detailed division of key tasks should be included. Furthermore, the scale of capital or in-kind contributions from each party to the business, and the method for valuing these contributions, must also be made clear. This is because the amount invested and the assets provided by each person can determine the equity stake or the profit-loss distribution ratio. How profits and losses generated during business operations will be distributed is one of the core contents of a joint venture agreement. The method and criteria for calculating profits and losses should be established, and the ratio by which the calculated profits and losses will be divided among the partners must be specified. Generally, distribution is based on the equity contribution ratio, but it can also be determined differently considering contribution level or roles. In case of losses, the scope of each party's responsibility and the method of loss sharing should also be agreed upon in advance and included in the agreement. Provisions preparing for unexpected situations, such as the business not proceeding as planned, or a partner withdrawing or passing away, are essential. Specific reasons for which the partnership can be terminated should be defined, and if the agreement is terminated, how the remaining assets and liabilities will be settled, including the method and ratio, must be clearly stated. Especially when a partner voluntarily withdraws, it is important to restrict the transfer of the withdrawing partner's shares or grant the remaining partners the right to preferentially purchase those shares to avoid disrupting the company's operations. If a partner withdraws when the business is doing well, failure to predetermine a settlement process, such as calculating goodwill, can lead to significant disputes. So careful consideration of this part is necessary. The agreement should also include content regarding liability for damages arising from a partner's failure to fulfill obligations or breach of contract. Rather than just stating that there is liability for damages, it is also worth considering including a penalty clause that requires payment of a certain amount in case of violation to enforce the fulfillment of obligations. Finally, it is common to include the duration of the agreement and the designated court jurisdiction for resolving disputes related to the agreement. As such, a joint venture agreement is not merely a formal procedure, but an essential safety net for the successful operation and sustainability of the business. Based on trust among partners, it is paramount to have thorough discussions at the business startup stage and draft an agreement that all partners are satisfied with and understand.